Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents. We are back again. May 30th, Supreme Court opinion relating to an order, Noem v. Doe. Noem being Kristi Noem, the Secretary of Homeland Security. And this case centers around the CHNV parole program, which was established in late 2022 and early 2023. CHNV stands for Cuba, Haiti, Nicaragua, and Venezuela. This program was started by the Department of Homeland Security, and non-citizens from those four countries were granted temporary permission or parole to live in the U.S. sometimes with work authorization. Parole was granted on a case-by-case basis after applicants passed a vetting process and had a U.S. sponsor. Then, on January 20th, 2025, the president issued an executive order directing the termination of all categorical parole programs, including the CHNV program. In response, the Department of Homeland Security ended all current protections for CHNV recipients, estimated at almost 500,000 people, and they did that immediately, at once. Not surprisingly, a class action lawsuit was filed in a Massachusetts district court challenging the mass termination, claiming that the blanket revocation was unlawful, violating immigration law, which requires individualized parole decisions. The district court agreed, issuing a temporary stay of the DHS termination order, and then the government asked the Supreme Court to lift the lower court's pause of their termination through a request for a stay. The application for stay was first presented to Justice Jackson, who then referred it to the full court under her power to do so. And then the full Supreme Court granted the government's request for a stay, meaning that the Department of Homeland Security may proceed with terminating the parole status of all CHNV recipients. The stay will be in effect until the First Circuit Court of Appeals hears the government's appeal, and possibly while the Supreme Court hears the case, if we get to that point. So, this is where we get to the actual text of this document, the dissent written by Justice Jackson. In the dissent, Jackson claims that the standard for a stay was not met, saying that the government failed to show that there would be irreparable harm if the stay were not granted. The main idea she is expressing is that there would be irreparable harm done to individuals that could not be undone if eventually the courts ruled the termination was unlawful. So basically she's saying that people who were deported as a result of the termination of the program would possibly have no recourse if the termination was ultimately ruled to be illegal. They would possibly not be allowed back in the country.
Full video located on our channel.